Soundcheck, deneme test. 1, 2, 3, 4, prova. Deneme. Soundcheck, deneme 1, 2, 3, 4, prova. Ses kontrol, deneme. 1, 2, 3, 4, hey, test. Prova, okey.
Testing. Okay. Good morning, welcome. We're going to start in a couple of minutes. Emila, welcome. Hello. Yeah, I don't want Emila taking notes, because I want her to input on the substantive topic.
Does that prevent it? Okay.
Generally. Actually, yeah, it's not really forte, it's not taking notes. Good morning, welcome. Don't feel you need to sit at the back. Come on up to the front. We don't bite. Really. We've still got Claudio, so I'm
Claudio is friendly with you, so you can sit next to him. Not just
did me. Okay, shall we begin? Shall we gently get started? Thank you, Nicolo.
Okay. Hello, good morning, everyone. My name is Nicolo Zingales. I'm a fellow at the Center of Technology and Society of the Getulio Vargas Foundation in Rio. And I want to welcome you to this workshop that is going to speak about a very important concept, I think, in the development of the social and legal norms that apply to online platforms. And the reason why I talk about social and legal norms is that this workshop is going to look beyond what the strict legal requirements for online platforms are in order to escape liability for user-generated content, and is going to look into what are the social expectations that people have regarding the role and responsibility that this platform should play, and the role that other stakeholders play in the management of online content. For example, some of the concepts that are associated with responsibility of platforms are should platforms play a role of proactive enforcement with regard to a particular set of rights? Should they provide a balanced system to adjudicate conflicting rights? And should they essentially ensure the protection of fundamental rights at all times? Obviously, these concepts are somewhat related, closely connected indeed, with the idea of intermediary liability, if not least because the way the intermediary liability legislation is drafted influences the behavior of these online platforms. So if there is no intermediary liability specific legislation, usually platforms have the discretion to adopt with their terms of service policies that might not be seen as responsible with regard to a particular set of rights. And likewise, if there are due diligence obligations in the intermediate liability legislation, platforms can be required to play this due diligence requirement in order to get the immunity from liability. So in these two ways, intermediate liability can influence responsibility, but the two concepts should be seen as different and distinct. And that's why we are going to focus on what terms of service can do in order to influence the responsibility of online platforms. And in this regard, we have a packed lineup of speakers, and we want to see what they think from their perspective, which is going to be quite diverse given the different organization from which they come, on the role and responsibility of stakeholders. So we're going to start from my right. We have Konstantinos Komaitis. Oh, okay. First, we have Robin Gross from IP Justice, Konstantino Komaitis from ISOC, Paolo Lanteri from WIPO. On my left, we have Marco Pancini from Google, Janine Muhlmann from APC Women, and Nick Susor from University of Technology in Queensland. And then we have a co-moderator, Joy, from APC. So I guess we're going to start looking into the issue of copyright, and then we're going to slowly move into another area of online content management, which is what companies, what online platforms do with regard to potentially offensive speech. So we're going to start first on my right. Sorry?
All right, so on the subject of copyright and intermediary liability, from the perspective of the users of the platform, I think it's important that we don't have rules that require the platform itself to be responsible for policing and controlling the activities of the users on the system. I think that when we shift that burden over to the internet service provider or the content provider, or excuse me, the content platform provider, that we could risk chilling innovation as businesses are going to be less willing to try new businesses if they're going to be held legally responsible for what their customers are doing. I think it can also chill freedom of expression to have this kind of policing and controlling of the user's activity going on. So from the perspective of the user, I think that it's important that we leave some space for innovation and for freedom of expression, and not go too far with requiring intermediaries responsibility to police and control the activities of their users. Thank you.
Thanks. I forgot to mention that you have to be short, so thank you for doing that spontaneously. Let's move to Konstantinos. As I understand, you don't want to focus just on copyright.
No, I'm going to take something. Hello, good morning, everyone, and it's great to see so many of you, even though it's this early in the morning. I'm going to take something that you've mentioned about social expectations, which essentially, you know, what do we mean? We are talking about user expectations, and if we expand it and we start seeing and trying to come up with a clearer understanding as to the role that platforms, whatever those platforms their function is performed within the internet. We need to understand that over the years the internet has sort of assigned roles to each and every stakeholder, and these roles have to be respected and they have to be very clear. Robin mentioned policing. I am going that we don't, platforms should not be policing the internet. I'm going to take a step back, and I would say that users have certain expectations from all actors that are participating in this thing that we call the internet. So in the context of platforms, they are expecting that they will be protected. Now they might be thinking of privacy. Some of them are thinking they're free speech and hate speech. Others are thinking the way their kids are protected. So it is very important to understand that when we're talking about platform responsibility, I want us to put it a little bit also in the context of the things that platforms have to employ, whether they're technical or social, the norms that are able to make sure that the internet functions in a balanced way and they don't really upset or the dynamics that have already been established. So I'll make only that point and then we can deliberate on it. Thanks.
Thank you. So, Paolo?
Good morning, everyone. Thank you very much, Nicolo. Let me start by disappointing you and and all the audience in several ways. First of all, I was not planning to be that short, and the reason why I was not planning to be that short is that WIPO comes here with very, very little answers and a lot of questions. The reason for that is that WIPO is a member-driven organization, and we have 197 member states that decides what we should do, and I don't think it will surprise anyone. Governments are not ready or don't feel comfortable in putting the issue of ISP liability in a multilateral framework such as WIPO. This is the first. So I don't have a position, I don't have an opinion. Nevertheless, I can share with you several considerations on how the framework in place can influence and can be useful to see a way forward in this debate. So if you allow me, I will go with this. Otherwise, I'll make it as short as possible. So, first of all, the language responsibility and the concept of platform is something to which we look with great interest, and it's something that we already, it's a similar approach that WIPO has undertaken since the beginning of, at least 15 years ago, we were already talking about responsibility instead of liability. How we see responsibility is a broader concept that includes liability. So maybe in this way, it's slightly different from the focus of this workshop. And also the concept of internet intermediaries is very much broad and can definitely be similar or identical to the concept of platform, which is, by the way, the first question we have, what we consider as being platform for the focus of the debate, for the scopus of the debate. So what WIPO does in this way is what member states ask us to do. What are the guiding principles when we are asked to do something such as commenting on a law or trying to answer a specific policy question? The only guiding principle we have are the international treaties that we administer. International treaties we administer on copyright, of course. This is very focus on that. What is the guidance that those international treaties gives us? This, I need you to walk you through some boring legal steps. There are 5 or 6 major aspects of that. First of all, we have a long list of rights that we consider need to be granted to right owners, copyright. At the same time, we have very much, possibly the most quoted provision is an agreed statement on the same article that recognizes the right of making available interactive network, which is the right that is often infringed in peer-to-peer platforms and file sharing, that says that if a third party that provides physical tools facilitating this communication to the public, this action does not amount to a communication to the public. This may fall outside this specific debate, but gives you a clear indication of the hands-off approach of the Internet treaties, of the copyright treaties in this debate. So really, they are not focusing on ISP liability or Internet intermediaries. Then we have provisions on enforcement. Again, they are very flexible and allow member states to basically set up their legal frameworks. In fact, all systems currently in place, they work like the European directive, the horizontal approach, the vertical approach in the US, several regulatory response legislation are all in line with the Internet treaties. However, already back in 2000, at the beginning of the 2000, the majority interpretation of this this provision provides for some clear guidance. Says that immunities are indispensable, and cooperation among players is possibly the best solution. At the same time, we need to maintain incentives for creation. And this is on the side of the rights. At the same, on the other hand, we have important provision on limitation and exceptions. Limitation and exceptions are the area where the tools where copyright already budgeting a balance between different interests, public interests. Many of those public interests reflect human rights, and several provisions in the copyright national legislation already provide a balance, for instance, for the benefit of the rights of persons with disabilities, access to knowledge, education and research rights. Furthermore, there are also specific indication that technology, digital rights management should not hinder the effectiveness of those free access to content, thereby indirectly protecting public interests and fundamental rights. So summarizing, there is a great flexibility on how to implement them. Enforcement should include also limitation and exceptions. Stakeholder agreements are an ideal solution, and technology needs to be part of that solution. Agreements and technology together, leaving for a moment aside the law, has proven very successful in other fields, and we can further discuss that together with the panel. Finally, member states have been discussing several issues on another stream of work focused on enforcement, the advisory committee on copyright, the advisory committee on enforcement. This committee has exclusively a mandate to exchange information. However, in this debate, there is a growing interest towards non-punitive measures, education as preventive measures, alternative dispute resolution, and so a focus on soft kind of enforcement measures. If we have time later, I found last night some very important inputs coming from documents that have been shared by governments and discussed in the context of WIPO that are quite recent and talk about the drafting of a possible policy recommendation. So in that debate, some of the issues we're discussing here have already been raised. For instance, there is a clear trend, and here I want to focus only on two aspects. There are problems, of course. Those voluntary remedies are not perfect, as already mentioned. They are sort of similar in the sense of the requirement for the remedy, and the remedy is usually the takedown of the content. It can be done to removal or blocking access, and it is a burden on the platform, while the remedy focusing, the request for the remedy is a burden of the right owners. So the focus here is what is pushing a platform to move towards voluntary agreements. Well, according to some member states in our committee, the motivation can be certainly education, can be certainly integrity of the business, but at the end of the day, it's mostly still about avoiding liability. So do we need, is law required or not? Or can we just go about getting stakeholders agreed on concrete solution? Sorry for being not short as required.
Thank you, Paolo. No, actually, I'm happy that you made the two very important points. One regarding exceptions and limitations. I think responsibility of platforms is also to ensure not the enforcement of rights only, but also of maintaining the same system of exception and limitation that is in place in the space outside the platform, so in the traditional copyright system. And the second point is regarding technology, how technologies today are used to enforce what basically the terms and conditions of these platforms are. And this is also a nice segue to the next speaker, who is going to be from Google. Google has in place this very effective system for detection, assessment of the legality of the content, and enforcement, which is Content ID. And in this way, they are doing basically what in a traditional setting would require several steps, and they do it in a very efficient way, and at the same time they allow right holders to profit from situations where an infringement is identified. So how can we ensure that these systems also take into account limitations and exceptions and further the public interest?
Thanks, Niccolo. So for who doesn't know me, I'm Marco Pancini from Google, for the Google office in Brussels. I would like to start from two principles that I think are very important in this debate we cannot forget before we get into the details. And first is the free flow of information, which is the reason why we are all here. And the internet is a very successful media, and actually the whole positive impact of the free flow information is under our eyes. And second is that a company like Google wants to be a responsible player in the ecosystem towards our user and towards our partners, towards all the other actors in the ecosystem. So if you look at this debate under these two pillars, you can see that there is not a tussle, but for sure there is some kind of balance that we need to find. And I think technology can help a lot in finding this balance, because technology is, especially when it's used with intelligence and having a clear target, like in this case, the example of Content ID can be very beneficial, because it's basically allowing us to use the algorithm that we are using in other contexts in order to provide maximum flexibility to the right owners in order to protect their content, monetize their content, or just simply monitor what's going on about their content on a platform like YouTube. But this cannot be the end of the story, because if you look at that from a pure legal perspective, that's for sure a voluntary action. You know, it's not is based on a legal framework, which is the DMCA. But then, what's about the limitation debate? What's about the debate in Europe around the e-commerce directive and the jurisdictional issues and the non-monitoring issues and so on? That's why I think we need. And I really like what our colleague from WIPO said. We really need to have a multi-stakeholder debate. And sorry again for repeating this word, but I think in this context makes more sense. And when I say multi-stakeholder debate, is a debate really involving all the different parties that need to give an opinion and need to give a guidance on how to, again, go back to the balance that I mentioned before between the free flow of information. They need to be responsible players. Sometimes we find ourselves at the middle of this debate, as intermediaries make sense, but sometimes in a legal and ethical debate around the voluntary measure is not the best place to be, because again, there should be more discussion between civil society, right owners, law enforcement body more in general on how to approach voluntary measure and how to approach all the issues that you mentioned in before. I would like to make a couple of examples. One is the e-commerce directive and the safe harbor of the e-commerce directive that is under permanent discussion, but still remains one of the core pillars of the European acquis, we would say. from a lot of parties, and we hear more and more that the e-commerce directive safe harbor is a privilege. I think it's not a privilege. I think it's the rule of the game, and it's a very clear and strong rule, which means that when you post content online, when you touch content online, when you have a direct contact with the content online, you are responsible for this content. And be responsible and be liable for the content means that you need to take action when a public authority or when an interested party following due process is asking you to take action towards this content. And I think it's a fair balance. It means at the same time that intermediaries are developing, in a certain sense, platforms that allows people to express their opinion, to do business, to just realize what they want, a specific goal that they want to achieve online. But intermediaries are also, in the moment when they're providing these services, held liable or held responsible if they are informed about the legality of the content. So all of this to say that I think that the legal framework found the balance that I was describing before between the free flow of information and the need to be responsible for intermediaries, especially in the European context. I'm not an expert of the DMCA, but I would like to stick on the European context. I think the real debate should not be about the privilege of the safe harbor of the Commerce Directive, but the real debate should be how we can use the safe harbor of the Commerce Directive in the global debate as a best practice vis-a-vis other jurisdiction, and the second should be what kind of measure can be put in place in order to improve and make stronger the safe harbor of the Commerce Directive. For sure, there is a whole area of the relationship between the different parties of the ecosystem when something wrong is found on a platform that should be better specified. The whole area of voluntary measure could be better specified and better regulated by multi-stakeholder agreement. For example, there are a lot of discussion this moment in Europe around follow the money that we believe it's a useful and interesting solution for enforcement. All these discussions should be, first of all, inclusive of all the different parties, and then be put under the umbrella of clear agreements which set the terms and conditions of how to implement this principle. So all this to say that I think there are no conflict between the principle that I expressed before of the free flow of information and being a responsible citizen and in the online environment. The real question is, I mean, the real problem is in the weeds. So how to make sure that we achieve this balance by respecting the rule of law, a full inclusion of all the interested parties in the debate, and be effective at the end. These are still open areas, but I think we have made a lot of steps towards a positive solution of this question, and actually I'm very, very curious to hear also from the audience what the audience thinks about that.
Thank you, Marco. You mentioned the M word, and I think it's important that we engage on a multi-stakeholder effort. That's what we are trying to do with the Dynamic Coalition that we'll have a meeting this afternoon at 2:30. And so we believe that there is a possibility to find some agreement on, the terms and conditions of the social contract. But another thing that you mentioned that I think is very relevant is how we can improve the safe harbor. And when we're talking about safe harbor, I'm thinking about the debate that there is in the US regarding the very broad safe harbor in Section 230 of the CDA, which gives essentially very broad, almost complete immunity for internet intermediaries for whatever choices they make with regard not to copyright, but other types of content. So this is an issue that comes up often in the context of online harassment. And I would like Jan to introduce us to this debate and say what the responsibility of companies, platforms indeed, should be in this context, and how can we frame the legislation or the social incentives in a way that they protect the rights of women online, but also other disadvantaged individuals that might be targeted by cyberbullying. So I leave it to you. Thank you.
Thanks, Niccolo. Cool. Thank you. I often feel very anxious when I start talking about something after 4 speakers like this who haven't mentioned any of the words that I might likely use, so just bear with me. So I work in the APC Women's Program, and our main concern is around violence against women online. Because whether it is death threats that women receive on Twitter, Facebook pages that are devoted to violence against women, or sexual and violent responses to YouTube videos, it's very clear that the violence women experience offline has extended into the online space. There's a very particular kind of consequence for this for women, and one of them is the chilling effects of freedom of speech and freedom of expression of women that Robin earlier alluded to. But it's not often something that we talk about, how violence against women is leading to the chilling of a particular kind of speech. And so to me, it makes very little sense, although it's not surprising, that conversations about intermediary liability rarely, if at all, talk about online harassment. And there was a workshop yesterday afternoon where that was very, very obvious, that gap was very obvious. Rather, the concern has been around intellectual property, which has a very particular set of imperatives, and that's a political imperative and an economic imperative. And yet those are not necessarily applied to like half the world's population when we talk about violence against women online. And this is because we live in a world where violence against women is normalized and it is invisibilized, and because of that it's not necessarily an issue that's raised often in any space. And as a result of this, the hundreds and thousands and millions of women who experience online violence don't know what to do. Where do you go? Who do you ask? What kind of help can you get? So APC has just completed some research in 7 countries in Africa, Asia, and Latin America, really looking at the domestic legal remedies and the remedies that women can find through internet intermediaries to respond to the violence that they experience. The study covered a number of companies, ranging from Facebook, Twitter, Google, YouTube, to internet service providers in the 7 countries that we're working in. And all of the things that we found related to content, particular kinds of content. And some of these are the creation of imposter profiles of women, often to discredit and defame them, the spreading of private and or sexually explicit photos with the intent to harm and blackmail, pages, comments, posts targeting women with gender-based hate, misogynistic slurs, threats of rape and torture, and other kinds of humiliation. And also the publication of personal information, identifying where women are, where they live. So when a threat like, I know where you live and I'm coming to find you and rape you happens, you know it's true. You know they have your address and you know they can find you. So this is the context that many women online live with and experience every day. And what we found in terms of the terms of service at the companies that we surveyed were the following. And again, it's not surprising. Most of the terms of service refer to illegal issues that involve a violation of copyright, financial fraud, extortion, child porn, but don't necessarily mention any human rights issues, especially those based on gender, sexuality, or related issues. Even when there is a clear definition of unacceptable use in the terms of service, it's not usually accompanied by the setting up of a clear and easy to access and transparent procedure to deal with complaints. So even if you complain, you don't know what happens to your complaint and how those decisions are made. We also know that most companies don't enact the disruption of services policy in relation to abusive behavior or acts of stalking, harassment, and threats, and suspending services is confined to instances when they are owed monies. If the law of the land does not take abusive, coercive messages sent via phone or SMS seriously, such as in cases of Mexico and Bosnia-Herzegovina, it's unlikely that companies would take any helpful action on behalf of women or any other vulnerable group being targeted. While most companies do have mechanisms in place to respond to these violations, but there's very little public information about how they work, as I've said earlier. We also don't know what kind of training staff receive and what kinds of values are informing the kinds of decisions that are being made. And lastly, which is very significant for us, is that there's a tendency to shift the burden of dealing with this kind of harassment to the state or national governments where the operations are located, or to individuals facing harassment. The responses we get are that law enforcement is responsible for addressing violence against women, and that a court order is essential to protect privacy rights, and that women and girls should take steps to keep themselves safe. This is exactly the kind of narrative that exists offline, where the burden of proof to show harm rests with victims. And here we have an opportunity to really begin to change the conversation, to talk about a set of norms and values that says, actually, the burden of proof to show the harm that we experience as a result of the actions of others is not ours. And I think we really are missing out on an important opportunity to really begin to shift things. And I'll just give you, to close so we can speak some more later on, just some of the recommendations that we are making. The first is that policies need to provide adequate protection to vulnerable communities. And I think often when we talk about the language of protection, there is an anxiety because the language of protection is often used to close down spaces. You can't have access to this content because it's harmful to women. We're doing it to protect you. So we really need to have a nuanced conversation that allows us to surface these particular issues and find solutions. Companies should also invest in capacity building for staff and personnel and have separate procedures for dealing with complaints that relate to online violence against women. And lastly, the last recommendation that I'll speak about is that agreements between the user and the company, such as terms of service and privacy policies, should make explicit references to online violence against women and not only a general prohibition against illegal use. And they should provide a transparent and easily accessible process for filing complaints where rights are violated. Thank you.
Thank you, Jan. I think one of the points that you touched on is very, very controversial right now, which is the privacy, how to basically preserve the privacy of the potential perpetrator of the harassment, let's say. So this is something that has recently come up in Brazil. There was an order by a judge 2 weeks ago which required the Apple and other, I think also Google, to delete apps that would allow anonymous comments, precisely because this would stimulate possible online bullying, and there would be no remedy against that because you wouldn't know who the perpetrator was. And the same issue came up in a different way, but in the Delphi case, one of the reasons why the court in Estonia held liable the platform was that it was allowing anonymous comments, and the system of review, according to the court, was not sufficient to deal with the potential issues raised. But I mean, these are issues that are cutting across the areas of intermediary liability, and I think Nick is in a good position to talk about the parallels between these two areas, given that he recently organized and moderated a workshop at the Australian IGF trying to compare the mechanisms of dealing with online content management in these two different areas.
Thank you, Nicola. I think this is a really important panel, a really important project actually, because we're talking a lot about responsibility of intermediaries, and we don't really have a common dialogue yet. And what it means is that in a lot of the sessions that I've seen this week and last week, we're talking often at cross purposes because we don't quite understand what each other want and what the different trade-offs might be. And it is a legitimately hard case. We're talking essentially about an essential tension between the efficiency with which we can enforce our laws on the one hand and the trouble we've had enforcing our laws in online contexts. And on the other hand, we're talking about a really classic liberal commitment to due process and full procedure of law, the rule of law. So the rule of law requires a number of different things. It requires transparency, public rules, it requires that the laws are predictable and certain, and it requires that they're enforced in a way that has appropriate safeguards for due process. So we're stuck here with a trade-off where we have to decide to what extent we're willing to give up due process provisions in order to gain efficiency in enforceability. And I think that's a legitimate hard choice that we just haven't got consensus on. So this is what worries me most about intermediary liability. I worry about, or platform responsibility, I worry about market deals that don't necessarily have the legitimacy of public law. So in order for law to be legitimate, it needs to be created in a process that is legitimate. And we don't have that certainty at the moment. In most of the cases when we're talking about platform responsibility, a lot of the cases, they're deals between industry representatives. And we don't have the procedural guarantees, we don't have the substantive guarantees to be sure that these laws represent the best outcome for the public, for users. I think there's a couple of things have come up over the last week. One of the key ways we can try to increase the legitimacy of these processes is by greater involvement of public interest groups. But in order to have that happen, we need user representatives who have a seat at the negotiating table. We need user representatives to be able to actually enforce the norms that are agreed in that negotiation process. And most of all, we need transparency. And that's what we don't have at the moment. When we're asking private actors to do regulatory things, when we're asking private actors to take on public functions of regulating behaviour, we don't have the standards of transparency that we require to trust that the law is being applied in a way that is legitimate, clear, and predictable. I think this leads us to the second big problem, and I'll just raise two quick points before we open it up to discussion. But essentially, I think we just don't have the data yet. We don't understand enough, and there are assumptions being made on both sides that we don't have the empirical evidence to support. We need much more information on what is currently happening, and also what is possible, what the trade-offs really are. Particularly, I think on that point, we often get stuck on these assumptions. So we say that, for example, website blocking or takedown notices can't be 100% effective. And we get focused on that 100% efficacy, and we don't necessarily look at how it might be practically effective. On the other hand, we make claims about whether or not a particular measure will break the internet or segment the internet into different regional jurisdictions. And to an extent, these are really legitimate concerns that we need to work through, but we need more data in order to make these claims with a little bit more predictability about what the actual effects. When we're talking, similarly on the other side, when we're talking about impositions of due process, we need more information to be able to tell what sort of trade-offs we're making on protection of individuals and vulnerable population on the one hand, and trade-offs to speech on the other hand. These are legitimate hard balancing acts that we just don't have consensus on. We don't have the ability to work out the effects of proposed measures. And the last point is that I think Malcolm from Links summed it up really well yesterday, that in a lot of cases, whether or not you like intermediary responsibility or liability depends on whether you like the substance of the law. And I think we really need to work quite hard when we're talking about general principles to step back from the substance of the law at hand. So to give you an example, I don't think that copyright that intermediaries should have greater responsibility than they currently do to enforce copyright norms. But I think that primarily because I think that the strength of copyright is too strong. It has tipped the balance for a desirable system. I worry about the effects on innovation that we spoke about earlier. I worry about the effects on due process for users. But importantly, I don't think that it's illegitimate for intermediaries to, or at least necessarily illegitimate for intermediaries to enforce public law. So I think there's a difference there, and there's a category mistake that we're making in a lot of these discussions, because we typically do start with copyright, and copyright takes over most of the discussions, and there's very heated debates about it. And because of that focus on the substance of the values and the norms that are being enforced, I think we lose something about this broader question of when should intermediaries be responsible and when should the individual be responsible for their own behaviour. And I think that's a completely different question to the substance of the law at hand.
Thank you. Joy, do you want to intervene?
Thanks. Well, I'm actually at this point going to try and sum up some of the streams and themes from this extraordinary range of panellists, and then open up actually to the audience and come and I'll bring the microphone down and see if we can get some of your questions and your reflections on this topic. So some of the themes coming out of this, I guess, are firstly around which rights are we talking about when we talk about platform responsibility for rights online. And obviously we've got some rights around author rights, copyright, intellectual property right owners, but we've got actually a whole range of other rights as well. Privacy rights, the right to be free from discrimination, free from harassment and violence. And so I see, and also, freedom to innovate and content creation. And I guess one of the difficult questions is that in the context of platform responsibility, are all rights equal, or are some rights more equal than others? Are we prioritising certain sets of rights because we think they're easier to enforce or avoid liability for than others? And if so, why? Is it easier to monitor and police and use intellectual property laws for satire and parody? Is that any more easy and 1-0 to do than violence against women online? I see. So we have these tensions. I think we also have the multi-stakeholder tensions that some of the panellists have mentioned. And the question of which remedies are adequate, and is there room for innovation in remedies? But I'd really like to open up to the audience and get some feedback and thoughts about this concept of responsibility. And I see, is there another microphone? Can I just pick this one up? While the panellists think about that, we'll get some responses. Anyone with a question? Yeah, okay. Just introduce yourself.
Thanks. This is not as much a question as a reflection on what's been said so far. My name's Manu Sporny. I'm the chairman of the Web Payments Community Group at the World Wide Web Consortium. My background is primarily in finance and banking. And the reason I'm interested in drawing a parallel between finance and banking and what all of the panelists have said this morning is that we can see what happens when you over-regulate a particular industry. And banking and finance is one of the most heavily regulated industries on the face of the planet. It is also one of the least innovative. Even when you look at some of the innovations that are coming out of banking and finance over the past half decade, it's arguable that some of the things that are labeled as innovations are really a joke. It's built on top of a very heavily regulated framework, and therefore the types of innovations are not the same types of innovations that we're used to coming out of the web. So I think we can use that as a measure of how much we should be regulating, these particular, and I'm not saying all regulation is bad, not even close, but when those regulations are put in place, it takes a lot of work to undo the regulations. If we're overzealous in the way that we regulate some of these practices online, it can be incredibly damaging, multi-decades worth of damage as far as innovation is concerned to a particular industry.
Thanks. I'll just get several comments and then we can... yes, so Bishaka?
Yeah, my name is Bishaka Datta and I work with a non-profit organization in India called Point of View. So I wanted to make a couple of comments and ask a question to the last two panelists. One is, I think, in terms of when we are talking about due process and online threats and coercion, etc., I don't think any of us are arguing that gender rights or the body of gender should be placed outside due process, right? Because that would be completely counterproductive. We actually want due process to address these things the way they do other human rights, so that's very important. The second thing is, I think, the way this, this gets framed, it's as if to address online threats and coercion, we have to clamp down on free expression and speech. And I think that's very troubling to many of us who are very strong advocates of free expression and speech. So again, I honestly don't think we're going to get anywhere by sort of through this binarized approach or this polarized approach. And we're seeing it in many things at the conference. Like yesterday we saw net neutrality versus access, right? We're seeing privacy versus the right to be forgotten. And sort of, standing on both sides and saying, no, I'm going to cling to this position and I'm going to cling to this, we're not going to be able to get to a realistic situation which meets the needs of users. So what I want to actually ask is, how can we, one is in terms of speech. I'm curious about whether we can look at certain forms of online threats and coercion as forms of hate speech as defined by the UN Special Rapporteur, and whether we can actually expand our understanding of free speech to say that, if somebody's free speech shuts down another person's free speech, then that's also a violation of free speech. And the other thing is, how can we sort of really work where we are not saying it's only intermediaries that have to take liability? I don't agree with that, but we clearly need some sort of tiered approach or something. So, yeah.
Okay, so I take one more and then we've got this one and then we can go to the panelists.
Yeah, mine is maybe not so much of a question, but more like a comment. I heard one panelist saying that maybe we should make e-commerce directive as an example or a best practice example for the whole world. I just want to say my idea that e-commerce directive, it can't be taken as a best practice if it can't be applied in European Union in 27 out of 27 member states. More than 15 have misapplied e-commerce directive. So it can't be taken as a best practice if even member states of European Union are unable to apply it. We have cases in Italy, we've had them. We have cases in Latvia, in Slovakia, in Poland, in Estonia, where intermediaries, regardless of fulfilling all the conditions of e-commerce directive, are still seen as strict liability subjects. And this has been seen by the courts as a just and fair approach. So I think the e-commerce directive does have a right idea inside. However, I am convinced that it is fundamentally flawed.
Okay, comments from the panelists perhaps before we go to the next ones? So it'll be you and you.
I can absolutely take the last one, and I agree that there are challenges in the implementation of the Commerce Directive, but if you look at the general trends, for sure court can question liabilities of intermediaries, and frankly speaking, if you look at the most worrying trend is when the court started to build a new concept, which is the active hosting concept, which moved away from the core of the Commerce Directive and created a new category of intermediaries that are in the middle between be intermediaries and be content provider, and so created also some confusion. But I think, for example, in some of the last Supreme Court decision in France, in Italy for the Vividown case, and hopefully also in the Delphi case, the court of human rights we hope will reinforce the principle that intermediaries are protected by the safe harbors only if, and then the conditions are still remain the same, but are protected from the safe harbor. But I agree on the issue of the implementation is not perfect.
Thanks. Very briefly, I want to go back to the gentleman that was talking about the payments and the overregulation. And yes, there needs, I think that it has become clear over the years that overregulating anything is not good, especially when it comes to the internet and the technology that is changing so fast, as it also has been proven that the safe harbors and this laissez-faire approach in the regulation of platforms has been proven to be beneficial for innovation. However, I think at the same time we need to make sure that we understand that those safe harbors do not provide any sort, should not be seen, better yet, or interpreted as any sort of an immunity. Platforms have responsibilities. They set normative principles that deal with issues of speech, issues of privacy. And this is not something that we haven't seen in the past. You know, we have various communities that have come together to create those social norms. And I am thinking, for example, right now, back in the 16th century, issues of Lex Mercatoria. Having said that, those were really bottom up. And what we're seeing right now is that in a lot of cases, platforms are creating top-down rules that are imposing on those communities. And in parallel, you know, anyone can say you can leave the community if you don't want, but we've also seen that exit from those communities is not as easy as one might think. So there needs to be this balancing act, because a lot of those norms that are being set determine user behavior, and we need to be very careful as to what sort of behavior we're encouraging or we're not encouraging within these communities.
Yes, very briefly, I would like to make two comments. One is an obvious statement regarding the appropriateness of reform on regulation. I think there is, of course, law is slower than technology, but I think there are also very good reasons for that. And it's just normal that from time to time, in a fast-moving environment like this one, of intermediaries and possible liability, at some point we need to address the opportunity of modifying the rules. And the other comment is regarding regulation. Okay, we all agree overregulation is bad. Overregulation is bad, but if regulation is not needed in general, is not the way forward, can someone tell me what would be the main driver, the main force that will make platforms wanted to become responsible? What would be the driver? Because at the end of the day, they are commercial players. They can't be driven by the good in general. Some sort of guidelines, I believe, should be provided by a neutral and third party that could be public authority.
Thank you for the assist. I actually want to say that that's exactly what we plan to do with the dynamic coalition. And you touched on, the technological neutrality. I think also is important. You know, when you regulate, if you decide to regulate, you leave the norms in such a way that they can be shaped by the judges, interpreted in a way that is in accordance with how the technology evolves. But I think Rebecca has a burning question there. Oh. Okay, so.
Any more responses we've got?
Do you have a microphone?
Yes, this woman here, and then yeah, go.
Nick, you'd said that online there's a trade-off between efficiency and due process, and that this becomes a legitimate choice at times. I'm here. Yeah. I'm troubled by this because from my understanding of the law, if there is an absence of due process, either substantive or procedural, that can lead to arbitrary violations of rights, and this can happen with impunity. I would like it if you could elaborate on what safeguard you think can replace due process as a principle, especially if efficiency is the value that we're choosing online.
And then you?
Thank you. Can you hear me?
Yes.
Thank you. Thank you very much. I think it's been a very interesting panel, and it seems like there's a lot of conversation about the need to balance. find the right balance between rights and responsibilities. I think there are some clear-cut cases where you have sites that are basically dedicated to illegal activity, where you have pirate sites that we heard earlier this week are also a major source of dissemination of child abuse images, of advertisements for prostitution, etc. So these sites are just illegal actors, right? And how can we go about handling those? Then I think there was a question, I think Google mentioned that you have to look in the weeds, you have to drill down into the weeds on a lot of these issues. We made some progress in the OECD principles on outlining at a high level, and in the Net Mundial principles at a high level of how you try to balance those at a very high level. We need to drill down. And I think we need to think about this in a continuum. If there are sites that are truly dedicated to illegal activity, that should be easier. Then there are going to be sites, and don't mean to pull you up, but YouTube, where there's a lot of legitimate content. Most of it is legitimate content on YouTube. You've done content ID. There are ways that you have to deal differently with different types of actors in the ecosystem. If we can take those dedicated to illegal activity and focus on those in the first instance, maybe we can make some progress.
Thanks.
Hi, I'm Andrew Bridges from Fenwick and West. To the Google comment about follow the money, is that perhaps just an expression of not in my backyard, saying go chase somebody else? Because let's look at the questions of efficiency, due process, administrability, and competence. Why are the financial intermediaries in a better position than the online intermediaries? I've had 5 clients be threatened with a cutoff of their payments simply because of the industry they're in. And arguably one can argue with the banks, but there is no 6 strikes policy for MasterCard and Visa. There's no graduated response mechanism. What do others propose to be the due process for the follow the money approach?
Thanks. We'll just take one more and then we'll go back to the panel. Yep.
Hi, I'm Rebecca McKinnon. I'll be speaking at greater length in the Dynamic Coalition, but I just thought I'd bring up one thing for those who may not be going to that meeting. When we're thinking about platform responsibility and what that means, I come from a human rights perspective, and since this hasn't been mentioned yet, I thought I'd mention the United Nations Guiding Principles on Business and Human Rights as perhaps a framework or part of the framework for thinking about what platform responsibility means. And according to the UN Guiding Principles, states have the primary responsibility for protecting human rights. And that, of course, means that laws and regulations should be consistent with human rights norms, which is, of course, a separate problem. And part of the, I think, challenge with platforms is sometimes they are subject to laws that are not sufficiently consistent with human rights norms, or that have not been thought through properly in enforcing other interests as in terms of what the human rights impact will be. So that's one of sort of the challenges that platforms face in responding to laws that may or may not be consistent with protecting human rights. But then secondly, businesses do have their own responsibility to respect human rights. And obviously that's challenging when they're operating within inconsistent state frameworks, but nonetheless, the UN Guiding Principles lay out a set of things that companies should be expected to do, including human rights due diligence. And so what this would mean in the context of terms of service would be that as you are constructing your terms of service and as you're putting together your processes for enforcement, are you conducting human rights due diligence about what the human rights impacts are going to be of these terms and of these processes, not just freedom of expression and privacy, but other human rights that may be implicated. And so I think one interesting thing to discuss this afternoon might be how can we help companies put together these due diligence processes, which, thanks to the GNI and some other processes, are more advanced when it comes to government requests, and there are clearer principles around how companies can handle government requests in a human rights compatible manner, but very little discussion and I think no consensus about how that should work when it comes to private enforcement or co-regulatory mechanisms and so on. And so I think there's a lot of useful fruit for discussion this afternoon.
Thanks, Rebecca. If we go back to the panel. Yep.
Yeah.
Thank you so much for all these questions. There's really, really good questions here on the conflict that I was talking about between legitimacy and due process. And I think one of the key points is we do get stuck in conflict. You're absolutely right. And we treat it as an either-or process. I don't think that's necessarily correct. So you asked particularly about limits to free speech. And absolutely, there are limits to free speech. We all accept that. The difficulty is in the hard cases where you've got a borderline judgment. You have a really tough time if you're an intermediary making that judgment call, and that's a risk to legitimacy. Where we have private organisations that are not accountable outside of the judicial process, that's when things get tough. But by focusing on those hard cases, I think we do get bogged down. And what seems to be coming out here is a really good suggestion, that there are a bulk of easier cases that might be worth investigating first. Now, they're not as simple, I think, as we've been necessarily talking about, but I think one of the key points is that this conflict between legitimacy and due process and efficiency is not really helpful. And the reason I think that is that we can imagine different mechanisms. I don't think that it has to be either state or either state or private regulation. So instead of thinking of it as a continuum between state on the one hand or private on the one hand and state on the other, think of it more as a pyramid where we can build in due process safeguards in regulatory solutions that see primary decisions being made at an intermediary level, perhaps with appropriate provisions for users who feel aggrieved by a particular decision to seek the more legitimate redress through a territorial judicial process, court. That's about it.
Yeah, to answer to the question, thanks for your question, David. We all agree, and I didn't mention manifestly legal content because we all agree that the worst of the worst of the internet has to be taken down, and so from this point of view, we are absolutely on the same page. I want to tell you that sometimes I was talking about going into the weeds because even on the worst of the worst, there are some questions that are raising. I just want to mention the case of the enforcement that we then, thanks to our automatic detection system of a pedopornographic image that was exchanged by a repeated offender that was already under investigation from FBI and NICMEC, and raised never any discussion around the possibility that technology can offer in order to detect the worst of the worst. So on these, we are all on the same page, but even on these, I think it's important for the sake of keep on enforcing against the worst of the worst to keep open the debate with the civil society, be accountable in explaining why and how we can go after the worst of the worst. So it's just to clarify that we agree that the worst of the worst has to be taken down across all the different cases. On the other question on follow the money, I'm sorry, for sake of time, I didn't express in a more complete way our position. Our position is not to shift the responsibility to going after the financial institution. The financial institution will look into the solutions that are available, and I agree with you about Visa, MasterCard, the importance of the rule of law and making sure that cutting the source of revenues of criminal organization is done in a way which is, again, under the rule of law. I was talking more about the initiative that we can take in relation to our advertising network to make sure that, going back to the worst of the worst, nobody that is selling or trading bad stuff online or illegal content online can use our advertising network in order to do that. And so it's a responsibility that we take as first on our platforms, on our properties. And on the discussion on the possible due diligence under human rights principle and guidelines of terms and conditions, I think that's a very important area to explore, and I think we need to look into this.
Thanks. I just want to comment on Bishaka's point, and that's to say, I definitely think that it's a kind of red herring, this binary between freedom of expression and vow. It seems as if we aren't on the same side, when actually we are. What we want is to create the kinds of conditions where all people are able to exercise free speech. And I think it's dangerous to create that binary, which doesn't take us further anyway. And I think it also raises the issue of why multi-stakeholderism is important. And the question to ask is, who has a stake in what? And what is the stake that different people have, and what that means in those conversations? And lastly, just the point that Rebecca made, one of our key recommendations from this research really is around the guidelines for business and human rights.
Want to respond?
Yeah, just very briefly, I want to respond to Dave's point, which I find very interesting, and I think it goes back to what I was trying to say, that a lot of these intermediaries are really bad actors. You know, they're disseminating child porn images, they promote prostitutions, they sell drugs that can kill people, etc., etc. And I think that this is where the problems begin, because these platforms are actually using the immunities of the safe harbors in order to to sustain themselves. Now, the big challenge is how, of course, you differentiate between those legitimate actors and those actors that are promoting illegal activities. And I really do not have an answer, but as part of the platform responsibility, especially for these established platforms, those who are engaging actually in legitimate and illegal acts, it is to actually differentiate themselves, and it is to start saying that you guys cannot be using something that we have really fought for, and we have really managed to use, to innovate, and we have worked together with many other actors in order to try to find solutions. So I really do not have an answer as to how this is done, but for me it is very important that we start actually contextualizing, you know, these are the platforms that we can work with, and these are the illegitimate actors, and possibly, and then we hear the issue, for example, you know, the way follow the money is used, you know, it's used across the board. Again, we need to be targeting those actors that are engaged, and we know that they're engaged in illegal acts, and we should not be creating general rules for everybody and questioning, for example, the safe harbors in a general context. We need to find a way, and possibly that will be done through cooperation, and I'm going to use again the M word, the multi-stakeholder cooperation, in order to be able to identify how this can be done.
Thank you. So let me just try to wrap up before we ask a last question. It seems that something that comes out strongly is that a way to overcome the imbalances might be exactly to have this multi-stakeholder discussion. And this is also not only to involve the users that might sometimes be excluded by particularly when there are agreements in the industry regarding, for example, voluntary measures or possible codes of conduct. But also because some, I think, of these communities don't talk to each other. So you have people that deal with copyright, people that deal with online harassment, women's rights, privacy, and they don't interact that much. So I think the IGF is a valuable place to do that. But in the end, the essence of the problem, I think, which needs to be deconstructed, is that there is a tension between, of course, due process on one hand, and the efficiency of the procedure that is adopted, and the extent to which freedom, to innovate can be hindered by a procedure which entitles everyone to be heard in every possible instances where there is a decision to be made. So in the case of online harassment, where the danger of harming someone might be very high, it can be problematic to wait until there is a full judicial procedure before acting. So this brings me to a question that I think motivated this panel and the concept of platform responsibility and the dynamic coalition, which is how can we enable a market-based solution which take into account human rights, which ensure that the mechanism that is in place also has these safeguards to respect due process, freedom of expression, privacy. Can we provide transparency so that users can make an informed choice and choose the right platform, choose the right privacy settings, and follow the companies that are adopting a platform responsibility? So I would like to ask each of the panelists to say what they think about how we can promote this concept of platform responsibility.
Okay.
Can we start? Yeah.
I think, I mean, that's a really tough question. I think the key, first off, is transparency. One of the problems with terms of service at the moment, one of the problems with seeing whether companies compete on the quality of their processes is that we just don't know what's going on in the vast majority of cases. There are some intermediaries who do a much better job of reporting on what they are actually doing than others. But for a lot of the time, we don't know what's going on. So there's not that competition for consumers to be able to make an informed choice. I think in order to reflect public values, we need 1, transparency, 2, participation in the negotiation process, and 3, some form of accountability when we do have those agreed norms that companies have breached, in order to make sure that the way in which those private decisions are being made is done in line with our public expectations.
It's very difficult to come after something so succinct because I think what Nick is saying is exactly some of what the findings we are and the recommendations that we have in our research. And I think just the one other point that I want to make is that when we are talking about the kinds of solutions that are necessary, we also need to look at so, for example, if we're looking at the constituency of women, we need to be very aware that there are different kinds of women, and responses and reporting mechanisms and transparency processes that might be suitable for women in the global north are not always necessarily suitable for women in the global south. Examples include things like if you make a report about something, the report could be very clear, but if you have to submit that report in English, it doesn't make any sense. So we really need to think about differentiated kinds of responses to different contexts.
Free action from our side. One is digital literacy, so we really need to invest in content online that inform user about their rights and also their the terms and conditions of the services, and give them information on how to report content and how to deal with controversial content. Second is transparency. We believe that transparency is very important because on the other side, all the action that we can take in order to improve the enforcement and improve the take-up of takedown, for example, of reporting of illegal content online, has to be counterbalanced of full transparency across all the board about our action towards content online. And third, I think there is absolutely a great opportunity here to talk together with all the different parties and get ideas and on how to make it better. Can be at the level of the way we write terms and conditions, can be at the level how we inform user about the terms and conditions. We tried with videos, we tried with interactive stuff, we tried even with the constituency of the right owners with videos, where our lead copyright expert Fred is in playing with puppets and try to explain copyright in an easy way and how we enforce copyright in an easy way. But there are plenty of ways that we can experiment from this point of view.
So how to budget in human rights in platform responsibility? Well, first of all, to me at least, this whole process of platform responsibility implies that we are dealing with responsible platform at the same time. So I believe we can focus and narrow with these kind of subjects that are willing to tackle this debate. Secondly, I believe we should have a reflection on the focus. Here we are talking about many different rights. Even in the same category of rights, there are different ways to enforce them. For instance, limitation of the selection and copyright. So I'm not 100% sure we can budget in the same technical or practical solution copyright, human rights, and many other things. Although we should try and we should think more about that and how to make a stream towards the same channel. And finally, in looking for solution, process is key, has already been mentioned. Of course, participation of different stakeholders, but process is key since the beginning of the start of the process. I saw being participating many remarkable initiatives in trying to solve words problem that started simply by forgetting one piece of the puzzle, and therefore they were not then awarded the credibility they should have deserved. So these are my 3 points and suggestions for future work.
Thanks. I think we've heard already transparency being mentioned, and I would mention it again. I think that there is need for clear terms of services. Users need to be able to understand what they're signing up to and what they're getting themselves into. A clear, robust, and robust accountability mechanisms. For me, the way I see accountability in this context is safety. They need to be able to know that there are redress system out there that they can, when they speak, they're not going to be excommunicated from the platform just because they speak and they say something. Communication is key. Regular updates as to what is happening. User empowerment. Allow them to ask questions and challenge those platforms in order to be able and possibly even shift the way those platforms are moving. And finally, I think that platforms should be asking all the time, what do users want? Without users, those platforms are empty vessels, and without users, we don't even have the internet, and we never actually ask users what they want. So it is important that we keep on asking users what it is that you want, what it is that you don't like, and why is it that you want this to happen.
Thank you. Thank you. Yes, I think that when I was first asked to be on this panel, and it was called Responsibility Online Content Management, it seems you could go in 2 different directions with this. The platform's responsibility to their customers or their responsibility for their customers' activity. I mean, this is really 2 different ways to look at it. Are they going to be, are these platforms going to be responsible for the potentially illegal activity of their customers, or are they is their primary responsibility to their customers to protect them, save finding some sort of illegal activity? So I think that was kind of an important distinction to make when we talk about responsibilities. I also think that the way forward is really just to try to make it, don't make being a legitimate customer so difficult. And I think that would be the way, the number 1 way to discourage piracy as well. And in the case of these ISPs, really the only way I think you can find them responsible for the activity of their customers in a fair way is if they're actually encouraging illegal behavior, if they're actually materially profiting from that behavior, if they have knowledge of that illegal activity. If you go further than that, I think we risk the balance of going too far in the other direction and will ultimately chill innovation and freedom of expression. Thank you.
Maybe there is time for a last question. Is there a remote question or? No,
Yeah.
just okay.
Is there a remote?
The remote moderator were to abuse of the position.
So we've got one more from Imola. She's been waiting patiently, and then Luca.
Sure.
Okay. Is this on? Yeah. Okay. My name is Emila Ushe. My name is Emila Ushe, and I work with the Association for Progressive Communications, APC. My question is directed to Konstantinos from ISOC. You said regulation by a neutral party would be ideal, right? regulation by a neutral party should be the ideal situation. But my question is, in Africa, we have the African Union. It has worked on a convention on cybersecurity and personal data protection, and the convention will enter into force upon ratification by at least 15 AU member states, and it contains provisions on, cybersecurity, and it has something on intermediary liabilities. It does not provide safe harbors for intermediaries, and so I wanted to find out. So the responsibility for online platforms. Is it within this framework? And maybe something that Robin has also mentioned already, is it responsibility to the governments because they will ratify this and they will want to, they would want to create new laws to work with the AU convention. So will it be responsibility within this law or responsibility to us users or just responsibility to their bottom is it bottom up or bottom line, to their bottom line? So I just want to know from the ISOC panelists.
So, okay, I don't think I mentioned neutral regulation. So going back a little bit, the automatic reaction of any government is to regulate. Okay, this is what they do. And also when it comes to responsibility, I would really like us not to think only responsibility of one party, but responsibility in the context of everybody is responsible for what is happening, especially when it's happening on the internet, because we all have interests on the internet and we all take from the internet what we want. In the context of platforms, we see increasingly that the more we regulate, the more problems we have in terms of understanding how these platforms function, their ability to innovate, and their ability actually to be the actors and have the position they want in the internet. This is me, this is not the Internet Society's position. It is, so when we regulate, I think that self-regulation is a very interesting way forward, but again, self-regulation should not be seen as a solution to everything, because self-regulation needs to come with certain safeguards. And I think this goes back to what Paolo was saying earlier, that, please identify a way whereby we cannot have this governmental regulation, but at the same time, we make sure that due process and accountability and all the rest of the boxes are ticked. And I think this is where cooperation starts. And we have seen in various aspects where platforms are engaging in self-regulatory frameworks with other actors in order to be able to set the frameworks. We need to understand, we need to capitalize on the experience that these actors have within the ecosystem, but at the same time, we need to be able to find mechanisms that allow for these actors to be held responsible. And I think that's the point that I was trying to make.
Yeah, no, it's not really a question, it's more a comment. Luca Belli from the Council of Europe. I wanted to build up a little bit on what has been said on the fact that platforms should mind to care about what users want. But I think platforms should, if we have to envisage and develop solutions to allow platform users to protect their rights, platform users should also be able to find them. The problem is not just to take care of what platform users want, but to enable them, empower them to find them. So that is one of the reasons why, by the way, I'm one of the evil mind behind the Platform Responsibility Coalition. So what we were thinking about is also to link these model contractual provisions to a sort of visual identity, some labels like the Creative Commons, the labels they see there. Why people choose Creative Commons labels? Because everyone can identify the labels and everyone can immediately know what are your rights if you use a certain badge. So if we develop together model contractual provisions and platform know that when they put them close to their terms of service, users will know that them will respect their rights. Platform will have an incentive on adopting this condition because they will have more clients, more customers, because customers will trust them because they respect their rights. Thank you.
That's a very nice closing, and I suggest that we take this debate to the afternoon session. So if you haven't managed to ask a question, you can come there at 2:30. And yeah, we'll have another half an hour, 1 hour and a half of discussion with 2 keynote speakers and very interactive participation. So you are very welcome. Yes, please give a round of applause for the panelists. Thank you.
Max for the work.